Let's cut to the chase at the top of this hot take. The United States Supreme Court, at least 7 members of it, are deeply skeptical about the Trump administration, its representations, that it's not in the middle of the night going to continue to deport and remove people to El Salvador to beat out the jurisdiction of the federal courts for supervision. That's why they entered an order at 1 o'clock in the morning, not a usual time for the tortoise slow Supreme Court that moves in a deliberative way. There was nothing deliberative about this. This was an immediate stop work order issued by the Supreme Court to the Trump administration. And now we've got the new filing that the Supreme Court commanded of the United States and its Solicitor General, John Sauer, about why shouldn't we keep the stay in place? Why doesn't the Supreme Court have jurisdiction over this? And what is going on below in the Northern District of Texas with Judge Hendricks and with the Fifth Circuit Court of Appeals? That's something the Supreme Court wants to know, and I don't think John Sauer just did it with his recent filing that I cover right here on Legal AF. There's a subscribe button. You're going to see it pop up there. Now's the time to help us continue to grow this pro-democracy channel. I mean, I can't think of any other better time. I mean, 50501 protest all around America. Here's your way. If you weren't able to commit to that protest or you weren't able to attend that protest, you can signal your protest here by being part of our audience at that intersection of law and politics and resistance. Legal AF. Let's get into it. So we reported around the clock, it seems, about this other case of at least 50 undocumenteds that the government claims are Tren de Aragua members of a criminal gang. They may be, or as Judge Wilkinson recently said in the Fourth Circuit, they may be Tren de Aragua, perhaps. They may not be. But what does that have to do with undermining their due process rights, their rights to notice, proper notice, and to give them time to file the writ of habeas corpus petition in various courts? Absolutely nothing. We're not here advocating to keep prisoners on the street so that they can murder innocent people. Although, frankly, as we all know or should know, that the vast majority of crime in America is committed by, put it in the comments, United States citizens. Yeah. By a much lower percentage, crime is committed by undocumenteds who, frankly, think about it, they don't want to get caught. They want to have a life. They're trying to find a path to citizenship. They commit crime. They commit lower crimes. When you hear about a mass shooting event, a mass casualty event, we just had one at Florida State University. That wasn't an undocumented. That wasn't Tren de Aragua. That was a child of a deputy sheriff. Okay, and that's who has access to guns and does the crimes that we're talking about. Let's put that aside for a minute, get back to John Sauer. So there was some very interesting language in the one paragraph order that came out at 1 o'clock in the morning. To remind you, it said 7-2 because Alito and Thomas, of course, have to be contrarians, said the government is directed not to remove any member of the putative class of detainees from the United States until further order of this court. You're invited to file your brief at your leisure, effectively. That's an FU to the government. That's an FU to Donald Trump. Yeah. We don't even need to see your brief anytime soon. We're going to keep this stay because we, as a Supreme Court, are trying to reinforce and protect and put a ring fence around our constitutional republic, our rule of law, our due process, our Fifth Amendment rights. And that's what we're going to do regardless of what you say, Mr. Sauer. So you can file your brief whenever you like, but the stay is staying in place. Now we'll see what happens as the case continues below. Judge Hendricks is the judge in the Northern District of Texas. He believes a lot of the things. He's not as deeply skeptical of the Trump administration as the Supreme Court is. And he's been giving them sort of the benefit of the doubt. Oh, I could issue that temporary restraining order. Oh, but is it really imminent? Is the flight's imminent? Are they fueling up? Are they telling them to put their seat backs in an upright position and put their snack tables closed? Are they doing that? Because if they're not doing that, I'm not sure. And I'm only going to do it for these 50 people in the Blue Bonnet facility here in Texas and not for anybody else. And that's a problem because now you're looking at hundreds, if not thousands of people who are scrambling to find lawyers, file in courts, and get justice. And justice sleeps. Let's be frank. You know, they made a big deal at the Fifth Circuit and in John Sauer's brief that I'll read you a little bit of about, well, the plaintiffs only gave the the district court and the appellate court 42 minutes before it filed its emergency stay. That's not a proper recitation of the procedural history of this case. The 16th of April, the ACLU, American Civil Liberties Union, filed their case. It's called AARP, et cetera, versus Donald J. Trump as president of the United States. They filed it in Texas. They got Judge Hendricks, a Trumper. I mean, he's not a Trumper. I mean, Obama appointed him first, but he was eventually confirmed under Trump. And he held a hearing, and he would refuse to issue a temporary restraining order because the government made a representation that they're not fueling the jets to El Salvador. We know what happened last time. See Armando Abrego Garcia. And so the judge's optimism, cockeyed optimism, did not sit well with the plaintiffs, and they ran to the Fifth Circuit Court of Appeals. And the Fifth Circuit said, well, we need a better record. We need the trial judge to do more fact-finding here. And we don't see it as an imminent threat, even though they had affidavits from 3 different immigration lawyers whose clients told them that they were given notice that they are getting on planes that evening. They rushed then and filed in the morning of Saturday an emergency application with the United States Supreme Court, having failed with Judge Hendricks, having failed with the Fifth Circuit. This is the last stop where these 50 guys are going to El Salvador, and we'll never hear from them again. And the Supreme Court took it seriously, especially on the backs of their April 8th decision, in which, in a unanimous ruling on an emergency application brought by the Trump administration, they said that due process and notice and writ of habeas corpus to enforce those constitutional rights is required for everyone and before they leave the country. In order to have due process, you have to have proper notice. In order to have proper notice, you can't undermine due process by putting it in a secret language that the people don't understand, like English. They're Spanish speakers. You just said they were Tren de Aragua. Put it in Spanish. No, they didn't do that. And then they gave them very little time. So if you don't give enough time to allow the lawyers to file, and you don't put it in English for proper notice, and even John Sauer in his filing for the government says, well, they filed a number of habeas corpus petitions, implying that they didn't file them for a number of other. So he says, well, the ones that filed, we're not going to detain, ... But if you didn't file you didn't get your lawyer, you didn't get your notice, you didn't file your writ, you're going. And that's the problem, John. May I call you John? What they're really upset about, and what we're seeing, it was held to the end of their brief, but what the Trump administration doesn't want, just like they don't want nationwide injunctions being imposed by federal judges, and that's up at the Supreme Court on the 15th. They don't want class actions. Let's have a breakout session quick on class actions. Class or collective actions are a way for a group of similarly situated people with similar injuries and damages to all join together and seek relief on behalf of the class. And if you're not, it needs a putative class representative, 1 person or 2 people, and then it has to have a defined group of people, like all the people that are about to be deported from the Blue Bonnet facility in the Northern District of Texas. That's pretty good for class definition. So you have a class, and then 1 person, 1 putative lawyer, 1 law firm, 1 American Civil Liberties Union filing can cover a multitude of these people in the class. So you only need 1 case, not 50 cases. You see, with 50 different judges or 10 different judges making rulings that aren't consistent. This way you get 1 ruling on 1 group of people that all are similarly situated. Look, they either are Tren de Aragua or they're not. Put them through due process, put them through a habeas corpus petition, let the evidence be put on by the government, and the best person win. That's how our system works. I mean, let me just preface it by saying this. If the quote-unquote evidence, skimpy evidence that they have against Armando Abrego Garcia is any indication of what the files look like against each one of these people, they'll have a pretty good shot at staying in the United States and proving that they're not MS-13 or not part of Tren de Aragua, okay? Because in Abrego Garcia, they had like a disgraced cop who got a double hearsay from an informant about Abrego wearing a baseball cap, Chicago Bulls. I mean, seriously? Oh, but I heard recently about Abrego Garcia. He's a human smuggler. He's a smuggler. He got caught in a car with 8 people in it. I don't know. A family going to any number of events could have up to 8 people in a car. It doesn't make grandma going to a soccer match a human trafficker. But, to Pam Bondi, it's a human trafficker. Yeah, okay. So, domestic violence. He beat up his wife. Look, I don't like any aspect of that. But, she filed her claim, the wife. She says she withdrew her claim, that the marriage was a little bit rocky at that moment and was put back together again. Doesn't mean he's this is again trying to tar and feather him to make people turn against him and his family in order to reduce the sympathy factor because they don't have anything else. That's what the government is now doing. So here's what the respondent's opposition to the emergency application says. It says that on page 2, the government has agreed there's no emergency because the government has agreed not to remove pursuant to the Alien Enemies Act. Listen to these words. Those alien enemy detainees who do file habeas claims, including the putative class representatives. Let's unpack that. So he's reserving for himself the right for the government to remove people not pursuant to the Alien Enemies Act. So you see how he's carved that out there? That's one. He says, we're not going to refrain from fueling the planes and sending them to El Salvador for all of the detainees, only those who are able in time to file a habeas claim. That's the problem. And then, of course, he doesn't want to recognize the class action status, which would protect all of them. And then he criticizes the ACLU, who was running around, starting with Judge Boasberg in the District of Columbia, trying to get him to assert jurisdiction over the notice issue. When he declined that, they went to Hendricks. When Hendricks declined in Texas to issue the injunction order, they ran to the Fifth Circuit. The Fifth Circuit declined it. They went to the United States Supreme Court as the court of last resort. What else procedurally were they supposed to do? Wave bye-bye on the tarmac as their clients flew to El Salvador? I mean, it is just depraved. Now, here's the real buried in the back of this filing. On page 7, they say that the lawyers that brought this case filed an emergency motion for a TRO to block their removal under the AEA, the Alien Enemies Act. They also filed a motion to certify a putative class of all non-citizens in custody in the Northern District of Texas who were, are, or will be subject to the proclamation of Donald Trump and or its implementation. And that's their problem, right? Besides the fact it's argued as premature. Here's what they say on page 12. John Sauer, remember, former criminal defense lawyer and appellate lawyer for Donald Trump. Now, your Solicitor General. Applicant's request is also substantively defective because applicants cannot show irreparable harm to themselves. Why not? No notice, constitutional violation, that's irreparable harm. They focus their request on securing injunctive relief on behalf of a putative class of detainees. Under Article 3, however, a plaintiff's remedy must be limited to providing relief to injured parties. Because no class has been certified, the putative class members are non-parties to the dispute. I don't think this is going to work. The impropriety of leveraging a proposed class, which is the bane of the Trump's existence. Because the Supreme Court, in its own order, referenced, seemingly with approval, the existence of a putative meaning it's not yet a class, but it could be. So we call it putative at this moment. They acknowledge the existence and I think endorse by extension the use of class action vehicle to protect these due process rights of these people all in the Northern District of Texas. I think that's a failing argument as well. All right, what's going to happen next? Let me wrap up the hot take this way. The Supreme Court has 2 pieces of paper. They almost never do oral argument, although they are doing oral argument in May on birthright citizenship and an angle related to nationwide injunction. So they won't hold oral argument. I don't think there'll be another filing. I think we'll now get a ruling sometime this week, but that stay and block stays in place the whole time. Could it be lifted if there's 5 votes of the United States Supreme Court to lift the stay and to let the appeal happen in due course, but who cares about these 50 people? Yes. We're going to see. That rubber meets the road about what the Supreme Court meant in its decision about Judge Zinnes in Maryland and her handling of the Abrego Garcia case and what their words mean when they took the case away from Judge Boasberg in D.C. and sent the case off to habeas corpus land in Texas. We're going to see what those words mean about, were they just hollowed words about due process and notice, or did they mean it before people leave? And we're going to get to the bottom of it right here. And we'll do it too here on Legal AF. Take a moment, hit the subscribe button. I mean, let me just mention, since we inserted the subscribe button, we're doubling our subscriptions. So I really do appreciate that you are focused on helping us here. This is another way to resist. I mean, I like 5501 protests and hands off all the same, but we're here every day at the intersection of law and politics and resistance. Join us, join our community and our fellowship, and be a part of it. And then once you subscribe, which is free, you'll get reminders for every one of our videos that we do, about 10 a day. So until my next hot take, this is Michael Popok reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.